Jackson may be facing a criminal mayhem in this case that we see involving Psycho Stu and the incident that happened during the wrestling match just last week. Now, as we looked at the facts of this case, we went through many, many different criminal charges, but as myself and many other attorneys have reviewed, none of them really fits the bill perfectly. So we'll get into why mayhem may be the thing that fits the bill, as it's a unique thing to California and maybe unique to this case. Of course, it's a fast facts version of the latest in legal news, a quick and dirty version. If you like this, make sure to like the video and leave a comment below. And of course, this is a legal mindset. We teach you to be your own judge. All right, so let's get right into the PowerPoint here and lead you guys right into the facts. So obviously, those that know, Roger Jackson has been under investigation by the LAPD for the beating of Psycho Stu, his opponent here, while he was unconscious. They are still in the investigation phase. They have not pressed any charges as of date. What we know right now is Stu is now at home recovering, but he had serious injuries. He is not dead. He's no longer at risk of death. He pulled through. He's fine, but not fine, right? He was seriously injured as part of this escapade. Now, there are no official criminal charges. One thing that's been mentioned, and one important thing here, is the police need testimony from Stu because they really need to decide, hey, which charges to press here, because Stu's testimony could change this. If part of this was, quote unquote, if this was on the script and Stu said, hey, this is on the script, that would be much different than saying, hey, this is totally unplanned, this is totally off script, et cetera, et cetera. So that is part of that calculus. The other thing that's been going on right now is a lot of criticism of the wrestling school for not cooperating with law enforcement, or rather being perceived that way. There's some people on the inside that said, hey, we were told not to cooperate. The wrestler that was restraining Raja said, hey, no, we weren't, we were told not to cooperate with law enforcement, not to say anything. So there's a little bit of that going on there. And we also have comments from Rampage Jackson, who has admitted his son should do some time and saying, hey, he should serve, a criminal penalty, which is a big thing for his behavior. But he's still, at the same time as he says, hey, my son should do some time for this, is saying, hey, well, Stu provoked it. It wouldn't have happened if Stu didn't do X, Y, Z. Although we have proof on camera that Raja was indeed very, very much at fault here in this situation. So getting that background, kind of getting caught up here. Of course, this is a summary. I know a lot of y'all that are really, really focused on the details will add more to this in the comments. But we're looking at the potential crimes. That's what I'm talking about. This is a law channel, a legal channel. So I went over previously some of the crimes, like attempted murder. And I also went over manslaughter, et cetera, and assault and battery. Now, I'm taking out manslaughter because he's not dead. So what we're left with for potential criminal charges are really attempted murder and assault and battery from what I discussed before. But here's the problem, and many other lawyers have said this. Attempted murder, it's very difficult to meet the elements, especially intent. Many other lawyers do not believe they meet these elements. On my show, when we looked at this, the chat, you guys thought we could meet the elements. It was 50-50 split. But remember, it's difficult to prove to a jury. And if 50% of chat says, hey, we think this is not provable, even if 50% does, that shows a jury will probably be split 50-50. So it will probably be hard to prove attempted murder. So in my book, I think for prosecutors, I think they're going to take attempted murder off the table. I don't think prosecutors are going to go attempted murder. But here's the problem with assault and battery. They're very easy to prove based on the facts. I think it's a slam dunk case for assault and battery, but many view the penalty as too light, saying this was beyond assault and battery. Assault and battery feels too light for what happened here. It feels too loose for what happened here. So what other options are there? Well, there's a uniquely California option, which after speaking with California attorneys, once again, I'm a Florida attorney, not a California attorney, but I have some very good California attorney friends. And after speaking with them about a particular crime that may apply, this might be the one that would be appropriate in this case. And I'll tell you why. It's mayhem. That's under California Penal Code Section 203. And that reads, every person who unlawfully and maliciously deprives a human being of a member of his body, or disables, disfigures, or renders it useless, or cuts the tongue, or puts out an eye, or slits the ear, nose, or lip, is guilty of mayhem. And there's a crime of aggravated mayhem, which deals with intentional permanent disability or disfigurement. So this is something that is beyond just simple assault. It requires more, right? So a simple assault could be, or assault and battery could be, putting someone in fear, and then, hitting them, right? But you could punch somebody, but that could really just be just a punch that really leaves nothing, no real serious damage, maybe a light bruise, maybe a small cut, but nothing really severe. It wouldn't raise to a higher level. But at a higher level, before there's murder, right, before there's anything else over there, you've got mayhem. You're saying, hey, this is something that caused a very serious injury, and it is elevated beyond the everyday, I got a boo-boo, I got a little bit of a scratch here. And what really it turns on is the injuries. So are the injuries sufficient? So you have to look at the injuries and say, are they sufficient? So let's look at what we have, the report of the injuries. He sustained a serious head injury and was unconscious upon arrival at the ER. His injuries include trauma to both the upper and lower jaws, a laceration to the upper lip, and a fracture to the maxilla bone, which unfortunately resulted in the loss of several teeth. Okay, so let's look at that. You've got trauma to the upper and lower jaw. I'm not clear whether that's going to be permanent or fixable, whatever. We'll see that. Laceration of the lip, so cut to the lip, and a fracture to the maxilla bone and a loss of teeth. So teeth are gone, cut to the lip, laceration of the lip, fracture to the bone, trauma to the upper and lower jaw. So if you look back at the statute here, the lip is included here if it's slit, and we do have a laceration of lip. So right there on its face, we've got at least that lip part to fit that in there. And beyond that, for the serious head injury, we don't know what type of permanent disability or disfigurement would result from that. So if he has permanent brain damage, if he has any sort of impediment, if there's anything else going on there, that could be far, far, far beyond the scope of just a normal everyday assault and battery, and that would go into the mayhem category. Now, do I think it's aggravated mayhem, intentional permanent disfigurement or disability? Probably not, right? Probably not. You might be able to make that argument, but based on these alone, without knowing the scope of the disability of the mental side, it's hard for me to say aggravated is a slam dunk. I think baseline mayhem could probably work here. The loss of the teeth and the cut to the lip, I think alone might be enough, as well as if these fractures and traumas are very severe. So, okay, let's say we get everyday mayhem. What's the penalty? Well, it's a felony. It's a felony. So Roger would become a felon, and he could get 2, 4, or 8 years in prison behind bars, and a fine of up to $10,000. Now, aggravated, of course, is up to life in prison with possibility of parole. I don't think he would get life. Now, if you look at it on the lowest level, let's say he got 2 years for this, 2 years behind bars for this. And of course, this might be modified as a first-time offender. There might be some sort of mitigation there or mitigating theory there. I think this might satisfy a balance between those that think, hey, assault and battery might be too light, but we're not going to get attempted murder. So perhaps mayhem is the right category for the Roger Jackson situation. I want to know what you guys think in the comments below, and I'll catch you on the next.